Well, officially, good morning.
Good morning.
First of all, I'd like to thank Paul for inviting me to speak this morning on the subject of ethics. Here I am, a conservative Republican, talking to this wonderful group of Democrats. Luckily, I'm not going to talk about politics, but I will tell you something that occurred 2 days ago. 2 days ago, I met with Kirsten Sinema, and I had heard her speak before, but we got together for about a half hour, and I have to say that she's a gift to the Democratic Party. And I think she's a real comer in this party, and a lot of people are going to vote for her because she's bright and she's thoughtful and she's everything we should expect of a public servant. So anyway, I want to tell you that I'm going to speak about the serious weaknesses in our criminal justice system. And I've given a lot of thought to this subject, and I decided I was just going to talk about that subject. The weaknesses that I see in this arena is the fact that prosecutors have many advantages over defense counsel. And what I want to do is tell you about some of those advantages and talk about a few cases that highlight these advantages. The first advantage is that prosecutors can use snitches. Now, another name for snitches, as you probably know, is an informer. And what happens usually is that a potential defendant or somebody in prison is willing to testify to get a lighter sentence or to get no sentence at all, go free. Now, the snitch system started in England in the 18th century. And at that time, they didn't call these people snitches, they were informers, but the official name, you can't believe, was Crown Witnesses. Now, the name Crown Witnesses indicates that these people were a special breed of people. In addition to not two microphones, can you believe this?
Much better, much better.
Okay. So not only did they escape prosecution, but they were given financial reward. And the financial reward was called blood money. Now, in America, we continued using the snitch system, but the prosecutors do not pay blood money. Instead, they pay for the informers with a reduced sentence or total freedom, which in my opinion is better than money. The second advantages came about in 1999, when the case of United States versus Singleton was decided by a Federal Circuit Court of Appeals. The court concluded that it is illegal for a defense attorney to pay a witness to testify, but it's not illegal for prosecutors to give snitches benefits that, in my opinion, are more important than that blood money. Now, the consequences of continuing the old English system really can be catastrophic, because so many defendants have been jailed for life or are on death row because a snitch who was an outright liar. Now, the third advantage to prosecutors is the result of a 1963 Supreme Court decision called Brady versus the state of Maryland. The court ruled that information obtained by a prosecutor that could help prove the innocence of a defendant must be turned over to the defendant counsel before trial. Now, theoretically, this benefits the defendant, but it really doesn't, because frequently it's violated by the prosecutors and they're never punished. Now, the fourth advantage is that federal prosecutors and most state prosecutors are immune from lawsuits by defendants who have been wrongly convicted due to prosecutorial misconduct. If there is a penalty, it's very, very small. In the paper would probably, in an article in the paper, it would probably say, innocent man gets 25 years in prison, dash, prosecutor gets 6 days in jail. But ordinarily, there is no light penalty because there's an immunity. Now, the fifth advantage also appears to favor the defendants, but in practice it does not. If prosecutors are unethical before or during a criminal trial, the judge and the defendant counsel are obligated to report the violation to the state disciplinary committee for lawyers. And I know about this because I served on the Arizona State Disciplinary Committee for 8 years. Now, in order to, before I go on, I want to tell you about a first-class snitch. This is an unbelievable story, but it is true. His name is Leslie Vernon White, and he was a career criminal in California. In order to get out of prison, he faked confessions of other criminals in jail with him, who were also in prison because he found out about the cases involving these people by reading the local newspaper. And then worming information out of the prosecutor's office and out of the police department by telephone calls from jail. So here's how he did it. He would call the police department telling them he was an assistant prosecutor, seeking information about the case. Then he would call the prosecutor's office and say that he was a member of the police department seeking information on the same case. So he would then offer himself as a snitch, indicating that the man he met in prison confessed to the crime. Leslie Vernon Smith was released from prison 12 times using this scandal. I mean, this scam. It was, and no one caught it. No one caught it. Eventually, it became so famous because some publicity came out about it. 60 Minutes had a segment on this story. Now, I'd like to take a few minutes to talk about the Don Bowles murder case. How many here have heard about the Don Bowles murder case?
Yeah, it's been going on for 20 years.
Mm-hmm. Well, several of you have. Well, let me just review the case, and because there's a reason. In June of 1976, Don Bowles, who was a well-known investigative reporter for the Arizona Republic, was murdered in Midtown Phoenix when someone placed a bomb under his car. The case was probably the second most famous murder case in the state of Arizona in its history. Anybody know the first one?
When he was young.
Ah, that's right. That's right. Can you think of a third one right now?
Yeah. What's going on now? What
The
is it?
Arias case.
Yeah.
Oh,
Okay.
yeah.
Okay, that's probably the third one. The Bowles case involved not one, but two snitches. The first snitch was named by Don Bowles as he lay mortally wounded on the ground next to his bombed-out car. Bowles said just 3 words: Adamson, Emprise, and Mafia. Unfortunately, the police department, the Attorney General's office, and the Arizona Republic ignored the words Emprise and Mafia. The only word that they put emphasis on was Adamson. Well, Adamson was a petty criminal and a con man, among other things, a drug taker and a whole lot of other things, who arranged the meeting with Bowles at the Clarendon Hotel the day of the bombing. So everybody knew he was involved. Later, he was arrested and wound up in jail pending his own trial for participating in the murder. While he was in jail, and this is another hard-to-believe story, but it's true, the police department delivered to Adamson a 5-inch thick portfolio of all the information they had accumulated on the murder. And he had that for 6 months in jail to review. That action by the Phoenix Police Department and the Attorney General who approved the transfer of these documents was as unethical as you could get in a criminal case. Now, Max Dunlap and James Robeson were accused of being co-conspirators in the murder of Don Bowles. It's a long story, but I'm just telling you what happened. At their trial, Adamson testified that Dunlap and Robeson were involved. Adamson claimed that Dunlap helped plan the murder, and Robeson planted the bomb. That's what he said. In return for his testimony, Adamson served 20 years instead of life imprisonment or the death sentence. He probably would have received the death sentence. At the end of 20 years, Adamson was put into a witness protection program, which was another added benefit that he didn't deserve. So, the second snitch was an attorney named Neil Roberts. Some of you might remember that name, but it was Neil Roberts who had a sleazy reputation. Roberts, along with Adamson, actually planned the murder. Early in the investigation, Roberts was interviewed by an assistant prosecutor, I should say, of Maricopa County, and was given total immunity for suggesting that perhaps businessman Kemper Marley and his friend Max Dunlap could have been involved in planning the murder. Neil Roberts offered no evidence, no solid evidence of this connection, just a theory, and for that he received total immunity for the case. He would have been highly involved in any trial that took place. Kemper Marley was never arrested or indicted because the police department had no evidence that he was involved. Now, because of these two snitches, Max Dunlap, an innocent man, died in the jail in 2010 when he was around 80 years old after spending 19 years behind bars. Now, let me add a personal note. Max Dunlap was a tax client of mine for 10 years before the murder of Don Bowles. I knew Max. He did not commit this crime. I was convinced of that. And I was also head of the Max Dunlap Defense Committee and worked pro bono for 20 years to get Max Dunlap out of prison. We came close, but before we could get a medical waiver, which we were working on, he died. He was also attacked in prison, and he almost was killed in prison, probably by the people who actually murdered Don Bowles. I can't tell you how many injustices were committed during that time, but let me tell you about one. In 1998, a habeas corpus petition was filed in the federal court seeking a new trial for Max Dunlap. Usually it takes around 4 months, 6 months, at the latest 1 year for the judge to decide a habeas corpus petition. In this case, the petition wasn't written. It decided for 6 years. That was a ploy to make the case go away. Now, I want to talk about the motivations of unethical prosecutors. The main motivation for attorney generals in particular is that they would like to move up in the political world. For example, many would like to become governor, or they would like to run for Congress. The more cases they win as the attorney general, the more popular they become. Now, in this case, Bruce Babbitt was the attorney general at the time of the Bowles murder in 1976. 2 years later, after the trial, he was elected governor of Arizona. And subsequently, he became Secretary of the Interior under President Bill Clinton. No punishment there. Now I'd like to tell you about another case. It's the case of the Central Park Five. You've heard about that? Okay. For those of you that haven't, I'm going to review it for you. The case was the subject of a documentary by Ken Burns that came out in 2012. And if you ever have a chance to hear that or see that documentary, I highly recommend it. Now this case involved, this was in 1989. 5 young Latino and black men were arrested for the rape of a 27-year-old white woman in Central Park, New York. She was found in the park near death, and the young man just happened to be in the park at that time. The 5 young men were intimidated by the police into confessing to the crime. All 5 were convicted and sentenced from 7 to 13 years. The prosecutorial misconduct involved the Brady versus Maryland case, known as the Brady Rule. The prosecutors had neglected to turn over to the defense attorney the proof that the DNA evidence didn't match any of the 5 defendants. Also, the prosecutors did not turn over evidence that the victim was found a long way from where the 5 young men were in Central Park that night. The young men suffered for up to 13 years in jail, and their families suffered as well. After they got out of jail, well, the reason they got out of jail was this. 11 years later, the actual rapist confessed to the crime. And the DNA evidence confirmed that he was indeed the rapist. So that after these 5 got out of prison, they sued the city of New York for violation of their civil rights. Now mind you, this was not a case against the prosecutors because they're immune. This was a case they brought to protect their civil rights. The case was postponed numerous times for under a 10-year period. This is another case that, well, if we don't do anything, it'll go away. And finally, this last year, 2014, the case was settled for $41 million. The money was divided between the 5, depending on how long they served in jail. They had served in jail anywhere from 7 years to 13. The original prosecutors were never punished. Last, I would like to tell you about the case of Senator Ted Stevens of Alaska. Senator Stevens was up for re-election in 2010. And at that time, the federal prosecutors indicted and convicted him for supposedly benefiting from improvements on his house by a local oil company. The prosecutors assumed that that was the equivalent of a bribe in return for favors provided by Senator Stevens to the company. In fact, there was no evidence of a quid pro quo by Senator Stevens to the oil company. But as a result of this negative publicity, just like in the Bowles case with the Arizona Republic, Senator Stevens lost the election. 6 months later, the federal judge learned that favorable information was not turned over to Senator Stevens' defense counsel. It was again the Brady Rule. And he felt that the Brady Rule was grossly violated. As a result, the verdict against Senator Stevens was reversed, and the Attorney General's office castigated the judge castigated the Attorney General's office, and it was pretty severe criticism. What I would tell you about that is, he's one of the few judges in this kind of a situation that would speak publicly about the unethical behavior of prosecutors. So I'd like to close on this note. In my research for this book and in the practice of law for almost 50 years, I've concluded that lawyers, business people, doctors, teachers, and others, for the most part, in majority, are ethical. The problem isn't those people. The problem is the bad apples that is increasing rapidly. And in addition to that, there is a standard of ethics for prosecutors to follow. Here are some of the words of Supreme Court Justice Robert Jackson, Some of you remember Robert Jackson. He was an outstanding Supreme Court justice. He was also a prosecuting attorney before he reached the Supreme Court, and he was the chief prosecutor at the Nuremberg trials. Highly respected. And these are the words that he gave to a large group of U.S. attorney prosecutors in 1940. The advice is significant then, now as it was then. Here's what he said. Winning should not be the ultimate goal. The ultimate goal should be doing what is right, even if that means from time to time backing down, reversing course, or conceding. When the government technically loses a case, it is really won if justice has been done. And I have a suggestion. And if you have any insight into anybody in this situation, I would suggest this, that every courthouse in the United States should have these words on the wall in a huge plaque so that everybody understands that this is the standard for prosecutors because they're getting away with murder. I brought some copies of my book with me if you'd like to buy them or buy one for the low price of $10. What I cover in the book is a whole lot of other things that I didn't cover today, but I just wanted to talk today about one subject that I feel strongly about. And I want to thank you for being here, and I'd also like to answer questions if you have some. Yes?
Well, there's another whole range of issues, David, which has to do with confessions and how confessions are used. And that goes back to the Miranda case that I worked on as a young lawyer in Phoenix. And the problem there is that police or prosecutors will get confessions under marginal circumstances and then use them and use other evidence that derives from the confessions and obtain convictions in that way rather than respecting the right of the suspect to remain silent or get a lawyer. And one of the issues in the Central Park 5 case was that these teenagers were interrogated for a day continuously without counsel, and they were told that if they confessed, they could go home, and instead the confessions that they gave were used against them and against each other, and they all were convicted in 2 different jury trials. The juries believed the confessions and the prosecutors rejected the arguments that defense counsel made that the confessions were coerced. And then the other part on the DNA is that the prosecutors knew that the teenager's DNA didn't match the victim. I don't know that they knew that the real rapist's DNA, who the real rapist was. They had the DNA in their office. He had been convicted of other crimes. They never connected the real perpetrator's DNA in this case, but they prosecuted the teenagers even though they knew at least that their DNA did not match the DNA on the victim.
Well, this is exactly why these people should be punished, because this was gross. This was really gross. But you're absolutely right. Why don't you tell the audience about the experience with the firm of Lewis and Roca with the need to have counsel before.
With what?
The need to have counsel.
Well, that's a whole subject for another time. But the short version is that the Miranda case was referred to Lewis and Roca in the summer of 1965 after he had been convicted and affirmed by the Arizona Supreme Court. So Lewis and Roca firm had nothing to do with the initial trial and appeal. The case came into the firm through the ACLU as a referral from Bob Corcoran, who later became an Arizona Supreme Court justice, came into John Flynn, who was then the state's leading criminal defense trial lawyer. This was a Freedy case. John Flynn got John Frank involved, who was then a constitutional scholar, appellate expert. They, together with others in the firm, including myself and Bob Jensen, did the briefs and won the case. But then that triggered a period of about 4 years when the firm was representing Miranda through a retrial and appeal in an atmosphere that was highly contentious in the community. There was lots of negative publicity about Miranda and the whole subject of guilty criminals getting free because the Supreme Court had said their confessions couldn't be used. And that caused considerable tension and some disagreement within the firm as to whether that was a good thing to be doing.
Well, let me add this.
Were you there at that time?
No,
You come later.
I was a partner at Lewis and Roca for a period of 17 years.
But
that happened before I
you
joined
came,
the firm. The point that you're making and that I'm trying to make here is some of the negative stuff that goes on with prosecutors is just terrible. It's just terrible. And that's why I'm suggesting that in every courthouse they should have a plaque like this, because I'm sure most prosecutors don't know what the standard is. Just don't know what the standard is. They know that if they win the case, they're going to go places.
Yeah, right.
But they don't know what the standard is. And I talk about in the book, I talk about the standard, and I talk about the fact that so many people don't understand ethical rules, I'm trying to think of one that is the most violated in the most...
Conflict?
The conflict of interest.
Oh, yeah.
The conflict of interest rule is probably the most violated rule of ethics, not only in the legal profession, but in the business profession and every other profession, because conflicts of interest are all over the place. And if you've been reading the paper lately, there's a conflict of interest situation going on right now with the governor and the superintendent of public instruction.
Yeah.
So, I mean, it's a wide range, but the conflicts of interest are just not understood by too many people.
There's another dimension, which is a public outcry dimension. In New York in particular, there had been a history of crimes by black teenagers and young men. And when that jogger was assaulted, there was really uproar and outrage, and the blacks are gaining control and all of that. They ought to do something about it. So those teenagers were arrested and tried in an atmosphere of public uproar and indignation and hate. And that, I think, has to be factored in here too, is that members of the public were on the juries that convicted those guys, rejecting the argument that the confessions were coerced. So it's us as well as them.
No, you're absolutely right. Let's go on to another question.
Can you say something about IQ levels? You know, when you have a witness or you're gathering information and a person is clearly not compass menti, whatever you call it, and yet that stuff goes on all the time. And I don't understand how a prosecutor can use the testimony of somebody in such a condition.
Well, you're naming another weakness in the system. That's one of the weaknesses in the system.
But is there a standard?
No.
There's
Well,
no standard.
On that, there probably isn't a standard.
Should there be a standard?
Well, that's a tough one to do. It's really a tough one to do. Yes.
With all of that going on, and having watched the O.J. Simpson trial and having been involved in another person's trial here in Arizona, here in Sedona and Camp Verde, what is all of this doing to the jury system? And is it time for that system to be looked at and maybe overhauled in some way?
Well, I'm not so sure about I don't think you can do away with the jury system, but I'll tell you this. There are things that you can do about what we talked about today, and that is snitches. Because there needs to be some control on the use of snitches. If a snitch gives some information that is solid, I mean, give you an example. He has the gun where that was used in the murder. Well, that's a snitch that has some concrete information. That could be okay. But for most of these snitches, are not giving real information. It's like, it's like I indicated in one of these cases. I mean, you're getting, with Adamson, I mean, he was not only a snitch, but they were helping him be a good snitch. I mean, it was incredible. Yes.
So who killed Don Bowles? I was a journalism major in the 70s in Arizona. It was a very big deal.
Okay, who killed Don Bowles? Well, first of all, the Emprise Corporation, owned dog tracks around the city of Phoenix. And they had connections with the mafia. There was another connection to the mafia that Don Bowles was investigating at the time. It was one of the technical companies in the city where somebody was stealing some material from this company, and it was highly rumored, and Don Bowles was investigating at the time he died, that it was the mafia. So there were two connections there to the mafia that I know of, but the mafia was pretty active at that time in Arizona. So who killed Don Bowles? Well, I can tell you this.
Who do lawyers think killed Don Bowles?
Well, Emprise Corporation may have been behind it, because Emprise Corporation was highly investigated by Don Bowles, and it was all over the newspapers, all over the country. And so that was an obvious place to investigate. But as I say, they ignored the word Emprise totally. And, some of the things that I told you about I didn't tell you the whole story because I didn't have time. But I do cover the Don Bowles case in my book. It's the first chapter in the book.
Okay.
And it's one of the reasons I wrote the book, because I was so taken by the bad behavior of the police department, of the Attorney General's office, of the Arizona Republic, of the judges, and I ended up writing a 10-page article about the subject via the Scottsdale Progress. Do you remember the Scottsdale Progress?
Love those people, the Marshalls.
The Marshalls.
Yes.
Jonathan Marshall was a good friend of mine, and when I became involved in the Bowles case, mind you, I'm a tax lawyer, I'm not a criminal lawyer. I was involved because I knew Max Dunlap. When I became involved, I went to the Arizona Republic because I had some information from a secretary that was involved with Neil Roberts, who had good information that wasn't known by anybody. And the person at the Arizona Republic said, oh no. And I knew him too. He said, no. Max Dunlap and Robeson are the two people who were involved. Then I went to Jonathan Marshall in the Scottsdale Progress. And Jonathan Marshall listened to me. And he said, I'd like to go talk to Max Dunlap. He was in prison. And he did. He went to interview Max Dunlap. And he came back and he called me up and he said, this man is innocent. And he was right. And Jonathan Marshall in the Scottsdale Progress wrote numerous articles about this, saying in every instance that Max Dunlap was not guilty. And he hired Don Devereaux, a private investigator, to help him get the information necessary to write these articles. I mean, he just didn't do this on my word or anybody else's word. He had a good investigator do the work. Yes, ma'am.
Tell them about the New York Times reporter and what she said.
Oh,
Molly.
yeah. This is another indication of what was going on. The New York Times has people in various states around the country. And one of them was in Colorado. New York Times sent Molly Ivins, who was a very, very respected newspaper person. And she came down, she was asked to come down and investigate this case. Well, she did. At the time, I was the chairman of the Max Dunlap Defense Committee. So she called me, and I told her what I knew about the case. And she said she had an appointment with Neil Roberts. Mind you, Neil Roberts never was indicted or anything, but he was highly involved in this case. She had an appointment for breakfast with Neil Roberts. I said, fine, why don't you ask him, why don't you talk to him and find out what you can find out from him? So she did. She finished the interview, she came back and called me, and she said, Neil Roberts told me outright that Max Dunlap was not guilty. So, there was two trials of the Bowles case. The first trial was it was closely after, about a year after the murder took place. And Dunlap and Robertson were convicted. 3 years later, the case went up on appeal to the Supreme Court of Arizona. They reversed the decision. And they reversed the decision because they said that there wasn't enough time given to the cross-examination of Neil Roberts. Not Neil Roberts, Adamson. Wasn't enough time given to the cross-examination of Adamson. So they reversed the case and said it'll have to be tried again. Well, it was to be tried without prejudice. That was the word used, without prejudice. That meant that it could be retried again. If it's with prejudice, then that's the end of the case. So Max Dunlap was now free. He petitioned the court to be tried immediately to clear his name. Now, first of all, if somebody's guilty, he's not going to do that. But he wanted to clear his name because, I mean, his family was involved, all his friends were involved, but they turned down the question. They turned it down and said, and the reason they turned it down was because the prosecutors could not use Adamson again because Adamson said he wouldn't testify unless he got further benefits. So for 10 years, he didn't get further benefits, and Max Dunlap and Robeson, well, Max Dunlap was free, but Robeson had some time to spend himself in prison. Not on this case, but on another case. So 10 years later, somebody went to the Attorney General's office, who I happen to know, and he wanted to make a name for himself. And so he wanted to reopen this case. And at that time, he got Adamson to agree to testify again for further benefits. And the further benefits was, after he testified, going into a witness protection program. And that's how he got into this program, because he was willing to get another benefit. And the difference in what happened in this instance, in the second trial, Robeson had no money. So the state had to appoint a lawyer for Robeson. They appointed the best, at that time, the best criminal lawyer in Phoenix, Tom Hensley. And he proved in the court that Adamson was an outright liar. And he was acquitted. Max Dunlap had a lawyer who I had advised him not to use, but he did. And to give you an example, he didn't use Molly Ivins at all. I mean, she talked to one of the main creators of this murder, and he didn't call her. I mean, that was just one instance of the terrible job that he did. But listen, the jury was out for a week, and they came back tighter, and they convicted.
And that's on Adamson's testimony?
Yeah.
That has already been shown to be not true?
Well, by the other
Yeah.
court. You see, the first time Adamson and Dunlap were tried together. Well, they were supposed to be
Conspirators.
conspirators.
Mhm.
And so and Max Dunlap wanted to be tried separately, because he didn't even know Robeson. He never saw him before in his life, and they were supposed to be co-conspirators of the second most important case, murder case in the state of Arizona. So I mean, there were numerous mistakes made, and when I say mistakes made, that's probably too generous. Yes.
My abiding concern these days is the disinterest the public has in justice. What they want is revenge. And it seems like the public accepts things they shouldn't accept. For example, Joe Arpaio is so wonderfully popular, but in tent cities sit people who have not been proven guilty. They're poor, and they can't get representation. They can't afford bond. But that's okay. People, they look at that and they really don't care, and that's become a national problem. Now, I think that was on one of the national programs of all these people being held because they're poor for years. They can't get into the court, and they can't. We should be outraged by that. Instead, Joe Arpaio is people's big hero. The second thing is, all that we're talking about talks about why people should not want judges elected, because the pressure to get reelected wins over somebody's good sense. And the very thing you talked about, I was the assistant to the presiding judge of the Phoenix Municipal Court for several years. And I saw in those courtrooms too, played out the same story, the overreach of the prosecutors. In fact, the chief prosecutor campaigned to become the chief judge of the Phoenix Municipal Court because he hated judges. That was the basis that he lobbied the Phoenix City Council to become the chief judge. Eventually, by the way, he was convicted of dealing in crack, if you will remember.
Well, this is not unusual.
No.
Wayne.
Do you see any changes in curriculum and in the beliefs of current law students because of the outrageous conduct in past years?
Well, thank you for that question, because this is a real of interest to me. I graduated law school, University of Michigan, and there was one course in ethics for 3 years in law school. It was taught by the law library professor who never practiced a day in his life. So it was a course we had to take, and it was one of these twice a week, one semester courses for an hour. Well, I later learned that that's not enough.
Yeah.
By any source of by any standard, that's not enough. And about 6 years ago, I was in communication with the dean of the Michigan Law School, who was a very good dean. And I told him my concerns about it. And subsequently, he asked me, I went to a reunion, and he asked me if I would come talk to the ethics class, which I did. But it was still one ethics class in 3 years of law school, and that is not enough. Now, it's not only lawyers. Business school, they have ethics classes, but it's not enough. Doctors, well, doctors are a separate issue, because in most cases, they're interested in bioethics, but they're not interested in the kind of ethics we're talking about. So, I researched this, and I tried to find some medical schools that, that had a bona fide ethics program, but it was very difficult to find one. But the point is, it's in every area, you see. And one other thing that you have to understand today, it's the issue of moral relativism in younger people. They've done 2 studies now. Now, what moral relativism is this? It's called that, but here's what it is. They had a study. They had 2 studies, as a matter of fact, in different times. and they asked the question, do you believe, this is from people from 18 to 35, do you believe that there is one standard of ethics of right and wrong? Or do you believe that you are responsible for determining what is ethical and what is not? Over 80% of the people said the latter. So what's happening today is we have, and this is called moral relativism, and I talk about this in the book. We have people who actually believe the latter. And if that's the case, then you're going to have people shooting themselves and shooting others as frequently as we're having now. Because they're the judge of what's ethical and what's not. So the other, you know, our universities, and that's a separate issue. Our universities, you know, do not have special courses in ethics. The first time that most people get a course in ethics is in grad school, if they get it at all. So, you know, a lot has to be done in regard to solving this problem. I think it can be solved, but it's going to take a lot of people to do it.
Well, it seems to me that a lot of the problem is the environment in which people work. And ethics, to a degree, has to be encouraged, like within a company, by the management. I mean, people by themselves, the little underlings, can't necessarily bring about the change in attitude of the masses within the company. So there's a problem in our corporate environment in regard to ethics. And perhaps you might think of that in terms of the pharmaceutical companies and what they do or business practices. And I don't have an answer for it, but it seems to be that profit often trumps perhaps what might be right in terms of people in general.
Yeah, well, I cover all these things in my book. But
I'll buy your book.
No, but let me mention something else, and this is really fascinating. It was in the newspaper, it was in the Wall Street Journal, I think it was in the New York Times. There's a company, and I can't remember the name of it right now, but this was in the last year. There's a company who will not hire college graduates to the business. Absolutely not. They hire college dropouts. Now think about this.
Now the rationale, what is it?
Well, the rationale is this. He said that the college graduates don't fit in very well to a business company. So he says, I take college dropouts because I can teach them what I want to teach them about the business, about ethics, if that's on his mind, about ethics, because they're not getting it in college. So, I mean, I find that fascinating. The business is doing great. They're having no problem with their hires. So, I mean, there you have it. I mean, we're falling down on education in lower grades. We're falling down on education on the college level. And this is the result of what we're getting. Yes, way in the back.
Well, that reminds me of Wisconsin, the changing of the mandate for the public institutions there. He wants to change the whole reason why people go to college. They're there to be trained to work in the workforce, not to have higher level thinking skills or higher aspirations. Just to change the whole mandate of the education system in the university system.
Well, are you saying this is good or this is bad?
No, this is bad. This is really undermining that higher level process and making it just, you know, let's just be truthful about this. We don't want people to think
It's too late by the time you get to college.
how they're going to live their
Well,
lives.
Dick has just made the comment that it's too late by the time they get to college. Well, I'll tell you, I'm not convinced of that. I think if the college has made efforts to teach ethics the way it should be taught, ordinarily you don't get it in undergrad school. I mean, it would be unusual. I think Hillsdale College in Michigan is one college that probably does teach ethics in undergrad school, but generally it doesn't happen. But it seems to me that if they don't get it in the lower ages, they still can get it in college if it's properly taught. What I told When I told the dean of the University of Michigan Law School, I said, look, having one class or two classes in ethics, I don't think is going to do it. What you have to do is have your whole professorial staff teach ethics on every subject that they're a specialty in. Because then, by the time they finish 3 years of law school, they're going to understand the ethical issues. Yes.
Do you remember the article, front page article, in October 1989? It said basically terrorists and all known gangsters are holding conventions in Phoenix, and all law enforcement know about it. And then it followed 2 more pages of, the information based on that front page.
That was in 1989?
1989, October.
Yeah.
Yeah. Do you remember that?
Vaguely, yes.
That article was retracted, if you could believe it. Okay, it was retracted all over. I had 3 copies, one in condominium up in Colorado, and my home in Scottsdale. They were stolen. And the archives in Washington, D.C., they were removed. The libraries in Phoenix, Glendale, and Mesa, they were removed from there. The films, microfilms were removed. And I was sprayed with ricin poison 3 times trying to get that microfilm.
Well, when I first moved to Phoenix in 1963, there was a lot of unethical behavior going on with the government in Arizona and in Phoenix.
Yeah.
And at that time, I got here just after. I think the people from 2 agencies were convicted of taking bribes.
Which agencies were they?
Yeah, that's right.
Which agencies were they?
It was a tax agency. It was the Bureau of Tax, I forget what it was called at that time. That was one of them, and the Corporation Commission. It was not unusual for them to be.
I don't think it's unusual today.
Well, that could be, but what I'm saying is, today compared to what it was when we moved here, was quite different.
Yeah, well, I submitted a report to Head Agent Turkovich in New York because the FBI office in Phoenix did nothing. I had 7 reports that I turned in through several different people, and they absolutely did nothing about a known terrorist. This is 1989, when that wasn't a big situation, okay? A guy by the name of Ahmed Manafai was a known murderer, killer, and he was part of Gaddafi's organization. He paid off the CIA to come into Arizona. He came here with a plane load of gold, paid off the CIA to come in, and that's why the FBI office did nothing to him.
Well, I'll tell you, because of time, I think we ought to close it, because a lot of people have to get to the office. But thank you very much, and if you'd like to go... My wife Marilyn will help you. But it was a pleasure talking with you all.
Yeah, thank you for coming.